The Supreme Court on Thursday restrained courts across the country to admit or pass order in any fresh suit or plea seeking a survey of religious places until the next hearing. It's a very important development that has taken place. And I'll just come to the point. The ruling came on the petitions challenging the constitutional validity of the Places of Worship Act. So let's take a look at what Apex Court had said. The matter is sub judice. No suit should be registered or proceedings undertaking until further order. No new suit related to places of worship can be registered while SC hears pleas challenging the act. In ongoing cases, court can't pass any effective interim or final orders, including orders for surveys. Civil court cannot run a race with the Supreme Court. Union government must file its counter affidavit regarding petitions challenging act in 4 weeks. Centre's counter affidavit must be uploaded online. Now, let me tell you what the Places of Worship Act is. The Narasimha Rao government introduced the act, prohibits the conversion of any place of worship, maintains its religious character as it existed on August 15, 1947, abates pending suits regarding religious conversions before August 15, 1947, excluded Ayodhya from the Act of scope, historical or archaeological monuments excluded, aims to uphold secularism by preventing disputes over places of worship. Now, exception to the Places of Worship Act. Ancient or historical monuments or archaeological sites, disputes settled between parties before Act's commencement. The Act does not apply to Ram Janambhoomi, as I said. Pleas challenging the Act. Takes away rights of Hindus, Jains, Buddhists and Sikhs to restore destroyed places of worship. Violates principle of secularism and rule of law. Bars right to approach courts, denying judicial remedy. Violates right to practice and profess religion and administer places of pilgrimage. Prevents reclaiming religious properties misappropriated by others. Challenges constitutional validity of section 2, 3, 4 of the Act. An arbitrary retrospective cut-off date of August 15, 1947. Arbitrary. Eighth, disputes over encroachment by invaders cannot be addressed by an act. Places are controversial because invaders destroyed them. But on the other hand, pleas in support of the act are also there. Their argument is protect secularism, a basic structure of the constitution, supports public order, fraternity, unity and secularism of the nation. Suits to reclaim temples destroyed by the invaders represent retrogression. Cites 2019 Ayodhya judgment which upheld 1991 Act. Now facts. Disputes that have reached court. Qutub Minar, Jama Masjid, Sambhal, Atala Mosque, Jaunpur, Jama Masjid, Mangaluru, Bhojshala, Dhar, Shamsi Masjid, Badaun, and Shahi Eidgah Mosque, Mathura, Jama Masjid, Fatehpur Sikri, Ajmer Sharif, Rajasthan. My questions are, will repealing the Act open the Pandora box? Is it possible? If the Act is repealed, will it open the Pandora box? That's one. But my second question is, what will happen to historical wrongs? Third question is, why do community initiatives fail? And the fourth is, when will Centre break its silence? I am joined by Ratan Sarda, author and political analyst, and advocate Nikhil Jain on this. First, I'll go to Mr. Sarda. Now the matter is in Supreme Court. The cases can be filed, not registered, surveys will not be taken. Supreme Court will have a final view. So my question is, do you think that the historical issues, frozen conflicts, are best resolved by community actions which have failed in India, or they require parliamentary and judicial intervention in this case, because it it had created a sort of a effect in multitude. Number of other cases have come up.
See, first of all, Karthik, I must congratulate the secular uh, and Islamist lobby for being able to stall every attempt by Hindus to reclaim their rightful place in the history. The Supreme Court itself had said that you cannot change the nature of the place of worship, but you can check the nature of the place of worship. That is why the surveys were allowed. Today, the Supreme Court has gone against very judgment. Now, I will be very blunt. This denial of history continuously before independence, when the RN origin theory put in by the British was thrown at us, and even we were the native Hindus were called invaders. Then there was refusal of Hindu reclamation of their heritage by Nehru denying Somnath temple. After that, there was continuous repression of Hindus in the case of Ram Mandir. They were denied. Fake affidavits were given. Fake history was given to people, and Mughals were made to look like roses, and Hindus were thrown as stupid, tribalistic, ignorant masses.